Good evening, everybody. Welcome to Albany Law School. It's a pleasure to see so many of you here. I see students, faculty, alumni, colleagues, and friends. And you're gathered here in person, but we also have a whole group online. So I want to say a special welcome to our folks who are joining by Zoom as well. So happy to have you here. Now, as we celebrate Albany Law School's 175th anniversary, something we're very proud of and shout about and wear our pins around, we're especially proud to host events that really reflect on the extraordinary legacy of our incredible alumni. Tonight, we come together to honor one of the most distinguished among them, Supreme Court Justice Robert H. Jackson, class of 1912. I think I forgot to introduce myself. Let me back up for a moment. I should have started with I'm Cinnamon Carlard, and I'm the very proud president and dean of Albany Law School, especially proud tonight, just in case I haven't met folks. Now, we're going to return to the very impressive Justice Jackson. Justice Jackson's career is remarkable not only for its breadth, but also for its enduring impact. As an Associate Justice of the Supreme Court of the United States, he truly helped shape American constitutional law. And as the United States Chief Prosecutor at the Nuremberg Trials, he played a defining role in advancing the rule of law on a global stage in one of the most important moments in time for the rule of law generally. His efforts helped to establish principles of accountability and fair process that continue to resonate today, 80 years later. Perhaps more than ever, we look to them and look to him and his legacy. Now, what makes Justice Jackson's legacy so very powerful is not only what he accomplished, but how he approached the law with a deep commitment to integrity, to fairness, and to the idea that the rule of law must be grounded in principle, even in, really, especially in the most challenging of circumstances. Those are values that remain central to our mission as a law school as we work every day to prepare students who are ready to practice, who are ready to serve, and who are ready to lead in the legacy of Justice Jackson. Now, we are very honored this evening to be joined by an outstanding panel who will help us explore Justice Jackson's life, his work, and his continuing influence on legal education, the rule of law, and practice. We are very grateful to have John Q. Barrett, the Benjamin Cardozo Professor of Law at St. John University in New York City, and the Elizabeth Lenna Fellow at the Robert H. Jackson Center in Jamestown, New York. He is a biographer and leading scholar of Justice Jackson's life and legacy, and I am part of his listserv where he shares stories about Justice Jackson, and they're phenomenal, and I feel so lucky to be part of that, and I've learned so much. And so it's such a pleasure to have you here in person, and thank you for being here tonight. It's a real pleasure. And then we have two of Albany Law's own, who we're very proud of, Professor Vincent Bonventry, who you all know, and whose work on courts and constitutional law has shaped generations of students at Albany Law, but also just his presence here, the work he does with the students, the opportunities that he gives them. It's very much a Justice Jackson kind of legacy in a lot of ways, and so very, very grateful to you. And then to Professor Rose Rameau, who is an internationally known expert in international law, who brings an incredibly valuable global perspective to this discussion. Her knowledge and expertise spans international dispute resolution, international human rights law, and then she has very deep expertise on international tribunals, which she's going to bring today. We're so lucky to have her at Albany Law School, so thank you. Now, programs like this one really reflect what we strive to do at Albany Law School: to connect history with present-day challenges, to engage thoughtfully with the law's most important and most difficult questions, and to prepare our students to carry forward and really progress and evolve the values exemplified by leaders like Justice Jackson. Now, many of you hopefully were able to join us earlier, just in the foyer just outside the room, to see an amazing display of photography of Justice Jackson and the Nuremberg Trials. Now, I want to extend my very sincere thanks to the Robert H. Jackson Center for making this display possible for tonight's event. We're deeply appreciative of our partnership with the center, whose collaboration really helps ensure that Justice Jackson's legacy continues to inform and inspire new generations. And we were hearing about all of the programming that you're doing this year to celebrate the anniversary, and with 500 people and here and there, so really deep thanks and appreciation for all of that work. I'm also very pleased to welcome Chester Rothstein. Chester's great uncle was among the select few photographers allowed at the trials, and we're very deeply grateful to you and your family for your dedication and preserving these important works and for your generosity in sharing them with Albany Law School. We've been waiting for this moment. I have to tell you, we've been talking about it, and we've all been very excited about it. So it's just incredible. And so thank you and welcome back. And it's great to see you. Finally, I would like to offer a very special thank you to our own, the wonderful presiding Justice Elizabeth Gary, Albany Law School class of 1990, who has done amazing work in connecting us with Chester and helping make this event possible, and who is just an enduring supporter of the law school and really, again, a wonderful testament to the legacy that we carry forward. So thank you. So again, I really appreciate you all for being here this evening, both in person and online. And it is now my pleasure to welcome our panel and begin what I know will be a very meaningful and thought-provoking conversation. So I believe that we'll start by welcoming Professor Barrett to the podium with great appreciation and excitement.
Good evening. It's an honor to be back here. I've had the opportunity to speak at Albany Law School quite a few times over the years, and the contemporary community is excellent and inspiring, and the historical company, Robert Jackson's with me every day, but here particularly maybe comes with a little bit of extra oomph. Thank you, Dean Carlarn, President Carlarn, Professors Bonventre and Rameau, and all the planners who did serious work to bring this about. Sachi Vines particularly had the point. I'd also thank my colleague Kristen McMahon, who's the president of the Robert Jackson Center, and we collaborate on things all the time. The Jackson Center is a co-sponsor here. I am going to set the table by introducing Robert H. Jackson, class of 1912, graduate. And the emphasis is on the word graduate, because I jokingly put in an email many months ago that I wanted to talk about Robert Jackson received a full law school education and then graduated as a title, because you often read that that didn't happen. And indeed, I've sort of added a quip, which I will finish with. You read he didn't go to college, he didn't go to law school, he didn't graduate from law school, he didn't have a law degree. And I will say wrong, 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 wrong. The college part's a little bit dubious, but I'm going to sort of talk about that, him as a person. This is the 80th anniversary year of the Nuremberg trial, 1945 to 1946, and today, April 15, in 1946, was a particularly auspicious Nuremberg day. It wasn't for Robert Jackson. He was in Vienna, in Allied-occupied former Austria, and he was doing consultations with General Mark Clark, who had headed the Fifth Army and was now running the occupation in Austria, and was meeting with Herbert Hoover. You didn't see that one coming, who was doing relief work in Austria in the devastation and the starvation that followed the Nazi surrender. But Jackson's team back in Nuremberg on April 15, 1946, was in the midst of cross-examining defense witnesses. And they were particularly in the middle of the case of defendant Ernst Kaltenbrunner, senior official of the Gestapo, who had called as a defense witness Rudolf Höss, who had been the commandant of Auschwitz. And on this date, 80 years back, John Harlan Amon, one of the senior prosecutors on Jackson's team, cross-examined Rudolf Höss, Auschwitz commandant, and got the most detailed, factual, remorse-free description of what he had done at Auschwitz as the commandant, because it had been his job. Because Hitler had instructed Himmler, who had instructed Eichmann, who had instructed Höss to do his part to exterminate the Jews of Europe. Now, yesterday was Yom HaShoah, International Holocaust Remembrance Day, and so that sort of juxtaposition of dates and that part of the Nuremberg legacy is a piece of the enormity of what an Albany Law School graduate went on to do. I'm going to talk about three things. First, just to sort of do it this way, the arrow. There we go. First, just a couple of glimpses. As the dean said, I'm a Jackson biographer. This is Jackson's memoir, which was a lost manuscript of Franklin Roosevelt. It was, at some point, an orientation gift to all ALS students. It is really both Roosevelt biography by Jackson and Jackson autobiography. And of course, these are two Albanians. This is a relationship that began in Albany in 1911. So that's a piece of my work. This is another thing that has been mentioned, which is my work on Jackson at Albany Law School. I have to say we did a version of this more than 20 years ago, and it's a pleasure to see A.J. Vicky, an assistant U.S. attorney here, who back then was the editor-in-chief of the Law Review as a 3L, and he and colleagues organized a year-long series of symposia and programs as issues of the Law Review in that year, which was the 50th anniversary of Jackson's death. And part of what I had the privilege to do, with the help from a lot of people here at Albany, was dig into the Albany Law School story. So actually debunking this Robert Jackson never went to law school, never graduated, never had a law degree stuff happened 20 years ago. And we know the right facts, but it's actually important to keep propagating them. So I point you back to this article, and you can see my thanks to AJ or Alan J. You had more hair, a longer name, back in this day of 2005. I also want to point you to the Jackson List, jacksonlist.com. This is a newsletter, it's a blog, it's an email. It reaches, I used to say 100,000 eyeballs, and then I realized, no, they have two eyes. It reaches 200,000 eyeballs, give or take, and you're all welcome. The cost is low, zero. The admission is liberal, everybody, and it's part of teaching the Jackson legacy. So I flag that for you. But I really want to turn to the man, and this will be three parts. First, Robert Jackson. Second, Robert Jackson's full law school education. And third, Robert Jackson's college education, as it were. This is the Jackson birthplace. He was born in 1892 in Spring Creek Township, Warren County, Pennsylvania. That's northwestern Pennsylvania. It's rural isolation. He is a rural American boyhood at the end of the 19th century. And except for the house no longer standing, Spring Creek today looks a lot like this. His ancestors, 3 generations back, were early white settlers, cleared the trees, were logging, and then became farmers. And 3 generations down, Robert Jackson was born. He grew up above the state line in New York State. His family moved there in time for him to begin first grade in a little town called Frewsburg. And then he rose up through a public high school education that was nothing special, but he was brilliant and accomplished and valedictorian. And then did a second senior year of high school in Jamestown, New York. And then, yes, did not go to a college as his next move. Became a law apprentice in a Jamestown law office of 2 lawyers, one of whom was a Politico, a Western New York Democrat, which is a bit of a rarity then and now. And that Politico brought his boy Jackson to Albany on a political mission in 1911 and introduced him to lots of people. And one of them was freshman state senator Frank Roosevelt from Dutchess County. You never know whose hand you're going to shake when you're 18 and they're 28. Jackson always remembered it. Roosevelt actually never did. But people and relationships ripen. Robert Jackson, after his legal education, which I will come back to, becomes a lawyer in 1913 and rises through 20 years of private practice to become a very significant New York State and regional and national lawyer. He's the elected head of the American Bar Association House of Delegates in 1932. He's an oil and gas lawyer. He's a trial lawyer. He's an appellate lawyer. He's a darling of Chief Judge Benjamin Cardozo at the New York Court of Appeals, although his record there was 2-5. Cardozo sponsors Jackson. Sometimes it's the client. Jackson is sponsored by Cardozo for admission to the American Law Institute. Being a New York lawyer was really all that Robert Jackson was dreaming of. And he had made a very comfortable living. He had a big white pillared house and a cabin cruiser on Chautauqua Lake. And I think he dreamed of being elected to the New York Court of Appeals. That's really where the law path was going. So coming back to Albany was kind of all he could hope for. But of course, when the phone rings, at least metaphorically, and your friend is president of the United States and you're being nominated for a presidential appointment, maybe you try out Washington. And Jackson, in a short run, rises as follows. 1934, appointed, nominated, and confirmed to be Assistant General Counsel in the Bureau of Revenue in the Treasury Department. IRS General Counsel is what we would call it today. Biggest law office on the face of the earth. 1935, detailed over to the Securities and Exchange Commission, heading up constitutional litigation. 1936, nominated and confirmed to be Assistant Attorney General. Spends a year heading the tax division, then a year heading the antitrust division. 1938, nominated and confirmed to be Solicitor General of the United States. In the 2 years that follows, argues about 50 times before the U.S. Supreme Court, which had become friendlier to the New Deal. That's a given. But Jackson was extremely effective in that appellate advocacy role. 1940, nominated and confirmed to be Attorney General of the United States. And 18 months later, nominated and confirmed to be an Associate Justice of the U.S. Supreme Court. He's 49 years old. That alone would be an amazing story. And I do think a lot of the meat of Robert Jackson is not lawyer in a technical sense, but statesman. And a lot of that is what he did in the 1930s into the 1940s. This is a fishing trip off the coast of Florida. I don't know what you wear when you're fishing, but they dressed better than we do. That's President Roosevelt nonchalantly gripping the post, which of course is what he needs to stand, and Jackson to Roosevelt's left. Harold Ickes is the last guy in the end. This is Jackson in 1935 when he is litigating the Public Utility Holding Company statute matter at the SEC, cover of Newsweek. He's becoming a national figure. This is Jackson in his SG office. Looks like burning the midnight oil, except I think it's a posed publicity photo. This is the court that Jackson begins to argue before in volume in 1937, 1938. It's the Hughes Court, speaking of governors of New York. It is the court of Brandeis, love the hair. It is the court of the hostility. The Four Horsemen are still there. Cardozo's in the back left, a soft spot of mine. And the first Roosevelt appointee is Justice Hugo Black on the back right corner. So this is just the start of the Roosevelt court. This is Jackson at the AG's desk during his 18 months heading the Justice Department. And this is where Jackson likely was heading in 1940. We forget this, and I think biography is very weak on this. But Robert Jackson was nearly, except for all the variables that would have had to cascade forward, president of the United States. And, you know, maybe Parker was nearly president of the United States, your alumnus. McKinley was president of the United States. There could have been an ALS string here because Franklin Roosevelt was retiring to Hyde Park after 2 terms, the American tradition. And yes, there would have been a Donnybrook between the New Dealers and the machine politicians of the urban centers. But Roosevelt's man was Jackson, and the New Dealers might have had the inside straight, and then Robert Jackson might have gotten the nomination, and then he might have been elected in 1940, and then who knows what kind of a war president he would have been. Things worked out just fine for us in the fact that he never became president. But it was very, very serious, and it didn't stop after 1940. It's back in 1944. It's back in 1948. It even softly is still there a little bit in 1952. That's the stature of Robert Jackson. This is July of 1941, Roosevelt signing the commission of Justice Jackson when he joins the Supreme Court. It looks like all happiness, but it turned out the Supreme Court was not such a happy place for Robert Jackson. What he found there, among his fellow Roosevelt appointees, fellow New Dealers, some of them close personal friends, was some people who he thought weren't on the up and up as judges. He thought they were still politicians, that they were pre-committed, that they didn't have a case at a time argument approach to the job, and they bullied others to sort of join them in that approach. And that became sort of a fight for the soul of the court and really divided it 5-4, Jackson with the top side, but Jackson almost quit. In fact, he got to the point of negotiating a partnership with a big New York City law firm. It's today and then called Simpson Thacher, but it would have been called Jackson Simpson Thacher. That was the deal. It was signed in ink in 1943, and then Jackson decided, I'll actually stay put and see how it goes. And, he did great judging. This is his writing of Edwards versus Arizona, the Oki right to travel case. This is his dissent in Korematsu. This is his opinion for the court in Wickard versus Filburn. This is an opinion for the court in West Virginia versus Barnett. There are major landmarks in these first 4 years, which are the pen of Robert Jackson, which is a gorgeous writing instrument in his hand. There he is on the back right in the rookie justice position. It is the Stone Court. In the middle is Chief Justice Harlan Fiske Stone, and all but one are Roosevelt appointees, but as I said, don't think that made them like-minded. And then Jackson got a call, a visitor, then a call, then a visit at the White House and so forth, in the spring of 1945, asking him to do something different. The new accidental president, Harry Truman, inherited this commitment that the Allies had made during the war that once we win militarily, we together will hold the arch criminals of Nazism accountable legally for starting it, for waging aggressive war. This is what had not been done to the Kaiser after the Great War 30 years earlier. This is what they were going to get right this time. And Jackson is told by Truman, you're the top legal figure in our country. You're in April already done with your opinions for the term. I know, I've checked, you're such a fast writer and, whatever. The Supreme Court takes a summer recess. This international plan is all ready to go. We've got an agreement. We're about to capture Hitler. We've got the evidence. And if we put you as the American, it will cause the British and the Russians and, the French too, to a point comparable stature. And we will do this international law project together. When your president asks, I think generally it's a totally appropriate thing to say yes. And Robert Jackson said yes. But remember, he was unhappy on the Supreme Court. What a wonderful trial separation. And maybe a kind of preview of what resignation would be. And war service, which he had really not had a chance to do. And legal work, his specialty, if you will. And so he says yes, and he finds out that it's a total bill of goods that he has signed up for. Hitler is dead 4 days later. So's Himmler, so's Goebbels. Goering they have, and they're not sure about Martin Bormann, so they try him in absentia. But the inner circle of Nazism is not entirely what gets prosecuted in Nuremberg, maybe 1 or 2 concentric circles out as arch criminals go. There's no allied agreement about how to do this with disparate legal systems. There's no gathered and assembled evidence. There's no location. There's no agreement on what it means to hold them accountable. The Soviets think we've basically already convicted them, so we'll display them before we execute them. In other words, a show trial. And Robert Jackson, due process, American rule of law man, says, that's not what I'm going to be part of. And he says to Truman, do you want me to sort of go the Soviet way? Truman says, no, do what you think is right. And so Robert Jackson becomes the architect of Nuremberg as we know it from the backside, from history. This is the repaired roof and the army occupation exterior of the Palace of Justice in Nuremberg. Those 4 windows on what we would call the 3rd floor are courtroom 600. This is the site of the 1945-1946 international trial of these arch criminals of Nazism, 21 defendants plus 6 organizations. It's a trial that runs from November through September 1945 to 1946, a 9-month trial. Robert Jackson misses a full year of the work of the Supreme Court. Already his colleagues, some of them are not fans of his because of the schism. They're jealous about why Jackson, not me, because he's a great lawyer and you're not. They're upset about 8 being stuck with the work of 9. There are over 22 4-4 cases that have to be re-argued the next term. So it's a complicated departure. Jackson tried to quit the court a number of times, and Truman said, oh, they can handle the work. Don't resign. I want you back there after this is all over. In hindsight, Jackson said, no justice ever should do a busman's holiday executive service like this, and today it wouldn't happen. This is Jackson at the podium. His opening on November 21, 1945 is one of the most gorgeous courtroom speeches in history. And his closing on July 26, 1946 is also in that category. It's a little bit more acerbic, but extremely powerful. And in between, Jackson is, yes, the chief prosecutor, administrator, running a staff. He wasn't such a great administrator, but he did a lot of it. And he's handling a lot of witness examinations. The spotlight finds his cross-examination of Hermann Goering, which had some bumpy passages, no doubt. But he had some dazzling, sort of like pull out the lightsaber and slice open the witness kinds of examinations. He did real trial work, plus all the diplomacy of going to Vienna and many other places during this year. These are the defendants: Goering in the left front corner of the box, Rudolf Hess, Ribbentrop, Keitel, Albert Speer, Schacht, etc. We can come back perhaps to some of these details during questioning. But it is a real public, due process-based American Bill of Rights employing fair trial. How do we know that? Because we can read every word, because we can listen to every word, because we can look at a judgment and see 18 convictions and 3 acquittals, which shows that it wasn't a show trial, including because Jackson was quite irked by one of those acquittals, which he thought was a miscarriage, that he had more than carried his prosecutorial burden of proof. And this is what the published Nuremberg documents look like. It's, among other things, a documentary case, a transcribed case, a long case. It's the basis of our historical understanding of what the Nazis were, of what the Holocaust was, of what aggressive war, the supreme international crime, was. But I want to jump back. This church was Albany Law School. Down on State Street, across from the Capitol, this was the Church of the Redeemer, which had become, by the early 20th century, a law school. This is Lark Street, just a couple blocks up the hill, where Jackson lived in an apartment. And so this is his law school landscape. This is Jackson, the ALS law student, class of 1912. This is his grades after one semester. So what is this Jackson never went to law school stuff? Well, let me start to unpack it. Robert Jackson did not go to a traditional college. He went to apprentice in a two-man law office. And after a year of that, when he was 18, one of these two, the more cerebral, not the politico, the other fellow, recommended a year of book learning. And so Jackson took this advice from Ben Dean and looked at the alternatives: New York City, but he didn't like the big city; Buffalo, but he didn't like the big city; Syracuse, he didn't like the little city; Albany, this big city, was the place for him. Why? The capital, the Court of Appeals, the appellate division, and an independent law school. And so in class and outside of class, this is a place where he could maximize his book learning. And it was on the cusp of transitioning from a 2-year program to a 3-year program. And Robert Jackson was a youth in a hurry. More than that, it gave him credit for the apprentice year. So in effect, he transferred in to the 2-year law school into the second year. This is the fall semester, February exams, of that first semester of the senior year of law school. And you can see his grades are quite dazzling, equity, a little bit of a bump in the road. Perfect attendance. This is his second semester. This is a more recent find. I didn't have this when I wrote the article. That 100 in corporations kind of jumps off the page. The 92 in evidence we'll come back to, 94 in crim, 91 in real estate, 95 in procedure. He is lighting the place up as a law student. And he is heading for graduation. Indeed, look at the top. On his transcript card, it says he graduated June 6, 12. He got a diploma. So, okay, he's gone to law school, and now he's graduating from law school. This is a glimpse of the education. I wish these were his notes, but they're a classmate's notes from the evidence course in that second semester in the spring of 12. And you can see on the left the handwritten notes. It's sort of squibs, decision by decision. One of the cases is Molyneux. One is Newberg. One is, and the handwriting gets hard. On the other side of the page is a sort of typed up outline, and I'm going to zoom in on the middle of the page. This is the topics covered. And then this is April 26, 1912, when they're covering expert opinion as to handwriting comparison. Under our New York statute, not allowed in US court, qualifying an expert on handwriting, yada, yada, yada. It's a kind of memorization style of legal education, and he was great at assimilating data. And remember, he got this very high grade in this evidence course, which went with the rest of his courses. That's why years later, this is in the 1930s, when he's about to be Solicitor General, you have headlines like this: Jackson, Albany graduate, stood high in class. Who's this guy? And you jump down, list of his classmates. He was considered, tied with Ernest Hornberg of Wellville, now an attorney at Olean, as the most brilliant man in the class. Some other stories refer to Ed Scheiberling as the most brilliant man of the class. He got the most awards at commencement. Down later in the story, law school classmates of Jackson agree they believed him most likely man to succeed. Some of this is hindsight. He's about to be Solicitor General, so you sort of like backfill the story. But the transcript doesn't lie. And Jackson's descriptions, his own and others, don't lie. He was a very hard worker and a very successful law student. And thus, he was heading for graduation. So what about this Robert Jackson never had a law degree thing? Well, he sure looks like he's in the graduating class, doesn't he? Oh, don't you spot him? Where would you put the superstar of the class? How about smack dab in the middle? See him in the bow tie? Baby face. He's 19, just turned 20. There he is in the middle. Baby face, fourth row up. Sure looks like he's in the graduating class. But there's something else in this photo. And I cropped it so we have Jackson on the top. And look at the two figures that I have bracketed on the side. This is the Pritchard problem of Albany Law School's class of 1912. Twin sisters, Clara and Clarissa Pritchard, were 20 years old. And they're in a class which has only 3 women. And maybe, there was some effort to be expansive and let them in, but then some second thoughts about women becoming lawyers. And the age 20 thing became an institutional ability to deny them their degrees. You see, the New York Court of Appeals had just decided you couldn't become a lawyer in New York till you were 21. And so in April of 1912, Albany Law School announced that it was going to follow the rule of the New York Court of Appeals and not give degrees to anyone who wasn't yet 21. And it seems clearly that it was aimed at the Pritchard sisters. They're in the Knickerbocker Press and the Albany Times and the New York Times. But guess who else was a baby in the class? So the kind of drive-by accidental victim of whatever this thing was that Albany was doing, age discrimination, was 20-year-old Robert Jackson. And thus, on June 6, what they give him is a diploma. In other words, your commission, if you will, having completed law school, but not a law degree. He'd finished law school. He'd satisfied all the requirements. He just didn't satisfy the age discriminators. Didn't bother him. He showed up at commencement. He took his diploma. He brought his girlfriend. All was well. And then he returned to Jamestown and apprenticed for an additional year. So he completes these 3 law preparatory years: apprentice, Albany Law School, apprentice. And as soon as he's 21, he takes and passes the New York bar, and that 20 years of private practice begins. This is decades later, when Jackson in 1941 comes to be the commencement speaker at Albany Law School. His classmate, Judge Isidore Bookstein of the New York State Supreme Court, is presenting Attorney General Jackson with an award named after Cardozo. They were pals, Jackson and Bookstein, Jackson and Cardozo, as I mentioned. And Jackson, at this point, is being very seriously brooded about as a future Chief Justice. Hughes has just announced his retirement. In the end, it's a multiple move, and this is when Jackson becomes Associate Justice. Stone is elevated, and Jackson is the backfill. But Jackson is quite fond of and staying connected to Albany Law School, but with a little tweak. He started to put in his footnote, in his extrajudicial writings, a list of his credentials, the way we all do. And sometimes you put in your educational background. And Jackson started to put in Robert H. Jackson, Albany Law School, 1941, nunc pro tunc, 1912. Meaning they gave him an honorary degree on this occasion, which was actually the degree he was entitled to back in 1912. And with that little Latin phrase, he's saying, I got a law degree in 1941 as if in 1912. It didn't bother him at all. None of it bothered him at all. Robert Jackson had this ability to sort of take on a challenge, be ambitious, be a statesman, wrap his arms around it, and go forward. And I think, that's what he did here, and that's what he did thereafter. So my final little piece, what about college? What about this apocrypha or somewhat true statement that Robert Jackson never went to college? Well, I can call it apocrypha a little bit, because if you look for a college that Robert Jackson went to, guess what? We're sitting in it. The degree that they withheld from him was a degree that didn't require undergraduate education. It was an LLB. It was a Bachelor of Law degree. And you actually see, not in Albany's name, but in many law schools, a vestige of an undergraduate law education when places are called the College of Law. Many universities have a law school that awards JDs and LLMs and SJDs that's still called a College of Law. Because until they formalized the requirement of an undergraduate degree, it was someplace you could come after high school. And in the words of 1910, 11, 12, they were called colleges. Cosmetology school and saddlery school and College of Law. These are all things that, people can do. Robert Jackson charted a path that was not so deficient or so uncredentialed by the standards of his time. So I thank you for your attention and your interest. Happy birthday to Albany Law School. He is very proud wherever he is, or was very proud when he was, to be a product of this institution, because what he found here was sort of everything he came here for. The environment that educated him, the peers that lifted him, the community that had the apex of state government that was the Empire State, that was part of what propelled him forward. Thank you.
I searched far and wide for that photo. We found it in the basement where the law review used to be. Now, AJ, you saw his grades. Would we have invited him onto law review? Conditionally, maybe. Well, anyway, thank you so much for inviting me here. And really, does John Barrett deserve to be the Cardozo chair? He really is extraordinary. Now, I don't deserve to be the Jackson chair, but I think Jackson was an even better writer than Cardozo. Those two are my favorite writers in the history of the court, but I think Jackson's even easier to read. What I'd like to do is I'd like to just talk about those landmark decisions by Justice Jackson that really pervade the curriculum here at Albany Law School, and in fact, at all law schools. So I teach constitutional law. We've got Jackson landmarks. Criminal law, Jackson landmarks. International law of war and crime. You got Jackson at Nuremberg. Supreme Court seminar. It's constantly about Jackson, and actually it's about comparing justices to Jackson. And also talking about, one of the things I like to talk about in this seminar is when I read some of Chief Justice John Roberts' opinions, I'm saying, boy, it kind of sounds like, I mean, he can't write as well, right? He's not a bad writer, but he can't write, well, who can write as well as Jackson, right? But it sounds a lot like Jackson speaking. And then you have to remember that Roberts clerked for Rehnquist. And who did Rehnquist clerk for? Robert Jackson. So a lot of what Robert Jackson wrote, a lot of those concepts, you see them passing through William Rehnquist onto Chief Justice John Roberts. And maybe that's why I'm a little biased toward the current Chief Justice. I mean, everybody knows West Virginia versus Barnett. Could you get, as John said, a more gorgeous opinion than West Virginia versus Barnett? Remember, this is a case which overruled a decision of the court just 3 years earlier, Minersville versus Gobitis. That didn't happen to stop Antonin Scalia from relying on Minersville versus Gobitis in a case in which he really demoted free exercise of religion, a decision which I've been fighting against ever since. That's the Oregon versus Smith. But 3 years prior to this, Minersville versus Gobitis, this overrules it. And you know the story. So many states and municipalities, they passed these laws and ordinances requiring school children to pledge allegiance to the flag. And they pledge, you could see how they're pledging allegiance to the flag. The Bellamy salute, right? The Bellamy salute. And so what would happen is if the students, like these Jehovah's Witness students, refused on religious grounds to salute the flag because you should pledge allegiance only to God, only to Jehovah. What would happen was under these state laws and under these municipalities, they would be expelled and their parents would be fined. Their parents would be fined. Well, in 1940, Minersville versus Gobitis, Felix Frankfurter, another great justice, he writes for the court and he upholds such a law. In the meantime, by the way, the New York Court of Appeals, speaking through Irvin Lehman, said, well, I'm not too sure about that damn law. And the Court of Appeals at that time oftentimes would take issue with what the United States Supreme Court did. And at that time, the United States Supreme Court oftentimes would cite the New York Court of Appeals, and they would reverse what they had just did, what they had just done. So West Virginia versus Barnett, Justice Jackson gets a majority of the court to say that, no, those laws violate freedom of religion, freedom of speech. And some of the words that he uses, we've all heard them, but I never pass up a chance to quote some of those. What about this one? The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, to free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. Who writes like that, right? And then he says freedom of speech and of press, assembly, and worship. they're susceptible of restriction only to prevent grave and immediate danger. This is 1943. You got the strict scrutiny test. That's Jackson talking about the strict scrutiny test, which we all take for granted today. And then he talks about struggles to coerce uniformity, to coerce the Jehovah's Witnesses to pledge allegiance to the flag, have been waged by many good as well as by evil men. And then he says, but the ultimate futility of such attempts to compel coherence is the lesson of every such effort, from the Roman drive to stamp out Christianity, the Inquisition as a means to religious and dynastic unity, the Siberian exiles as a mean to Russian unity, down to the fast-failing efforts of our present totalitarian enemies. And what about this line? Those, and Henry Abraham, when I did my graduate work, he used to be able to recite this from memory, and he loved this line. Those who begin coercive elimination of dissent soon find themselves exterminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard. How powerful is that, right? It seems trite but necessary to say that the First Amendment to our Constitution was specifically designed to avoid these ends by avoiding these beginnings. But freedom to differ is not limited to things that don't matter much. The test of its substance is the right to differ as to things that touch the heart of the existing order. If there's any fixed star in our constitutional constellation, is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. I mean, how do you improve upon that? I feel bad for any of the justices, sitting on the court today, because they're all reading Jackson opinions. I mean, they cite these Jackson opinions all the time, right? And if you ask them, they will all say, yeah, I wish I could write like Jackson. Who doesn't? Korematsu, 1944. We all know about that. Japanese Americans forced to evacuate their homes, and they were put in internment camps. By the way, the Korematsu decision was very recently overruled. It was overruled as an aside in Trump versus Hawaii, the Muslim ban. Oh, that's right, it wasn't a Muslim ban. Whatever the heck it was, yeah. It was overruled in that case as an aside. Chief Justice Roberts said, in case it's not clear to anybody, it's been overruled. Jackson didn't wait that long. Jackson in 1944, he dissented, right? The court upheld it, but Jackson dissented. Korematsu was born on our soil, of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. If any fundamental assumption underlies our system, it is that guilt is personal and not inheritable. But here is an attempt, the order for evacuation and internment. Here's an attempt to make an otherwise innocent act a crime merely because this prisoner is the son of parents as to whom he had no choice and belongs to a race for which there is no way to resign. It would be impractical and dangerous idealism, because he was very realistic, Jackson. He wasn't any pie-in-the-sky guy, very, very realistic. It would be impracticable and dangerous idealism to expect or insist that each specific military command will conform to conventional tests of constitutionality. The armed services must protect society, not merely the Constitution. But if we cannot confine military expedience by the Constitution, neither would I distort the Constitution to approve all that the military may deem expedient. That is what the court appears to be doing, whether consciously or not. We may as well say that any military order will be constitutional and have done with it. But then he says, but a judicial construction of the Due Process Clause that will sustain this order is a subtle blow to liberty, a more subtle blow than the promulgation of the order itself. A military order, however unconstitutional, is not apt to last longer than the military emergency. But once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order, the court for all times has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of urgent need. Well, we haven't been seeing any of that. Every repetition embeds that principle more deeply in our law and thinking and expands it to new purposes. All who observe the work of courts are familiar with what Judge Cardozo described as the tendency of a principle to expand itself to the limit of its logic. My duties as a justice, as I see them, do not require me to make a military judgment about the evacuation and detention program, whether there was a reasonable military necessity. I do not suggest that courts should have attempted to interfere with the Army in carrying out its task. But I do not think they may be asked, that's the courts, to execute a military expedient that has no place in the law under the Constitution. I would reverse the judgment and discharge the passenger. 1944. Of course, everybody today, well, just about everybody today, condemns that decision. But it was a popular decision. Right? Youngstown, Sheet and Tube. I mean, all these it's like one landmark after another landmark after another one. Youngstown, Sheet and Tube, you know, Harry Truman, he did not want the steel mills to be closed by the strike. So he wanted to keep them over. So he decided that the steel mills shall be taken over by his administration to keep them working, as would be required to make sure we had steel to carry out the Korean War. But in Youngstown, Sheet and Tube, the United States Supreme Court, they invalidated Truman's order. They invalidated the seizure of the steel mills. But it's not the majority opinion that we remember. It's the concurring opinion of Jackson. The majority opinion was written by Hugo Black, another appointee, of course, of FDR. He and Jackson didn't get along. They didn't get along. They had a very different way of deciding constitutional cases. But so Hugo Black writes the majority opinion, and he says, look, if the Constitution doesn't say the president can do this, that's the end of the story. Well, I don't know about that. And Jackson basically said the same thing. In his concurring opinion, which really is the law and is always now repeated, the comprehensive and undefined presidential powers hold both practical advantages and grave dangers to the country. It will impress anyone who has served as legal advisor to a president in time of transition and public anxiety. The teachings of that experience are probably a more realistic influence on my views than conventional materials of judicial decision, which seem unduly to accentuate doctrine and legal fiction, are true. A judge, like an executive advisor, may be surprised at the poverty of really useful and unambiguous authority applicable to concrete problems of executive power as they actually present themselves. A century and a half of partisan debate and scholarly speculation yields no net result. That was one of the things that I loved about the Cook Symposium we had a couple of days ago. The three women from the Court of Appeals, they made it clear these cases get to the high courts, whether it's the Supreme Court or the Court of Appeals. It's tough. You just can't rely on a quotation grabbed from one opinion, a dichotomy, direct, indirect, omission, commission, or the latest one, activity versus inactivity. You can't rely on those. Those don't solve real problems, right? A century and a half of partisan debate and scholarly speculation yields no net result, but only supplies more or less apt quotations from respected sources on each side of any question. They largely cancel each other out. The opinions of judges, no less than executives and publicists, often suffer the infirmity of confusing the issue of a power's validity with the cause it is invoked to promote, of confounding the permanent executive office with its temporary occupant. And we certainly see that today. We certainly see that today. We've seen that in several opinions the last few years, where the Chief Justice will say, look, this case is not about the current occupant of the White House. This is about the office of the presidency. In other words, forget about whether you like this guy or not. That's not what the case is about. Unfortunately, there's about 6 of them on the court that only decide cases based upon whether they like them or not. But no doctrine that the court could promulgate would seem to me more sinister and alarming than that a president whose conduct of foreign affairs is so largely uncontrolled and often even is unknown can vastly enlarge his mastery over internal affairs of the country by his own commitment of the nation's armed forces to some foreign adventure. The Constitution did not contemplate that the title Commander-in-Chief of the Army and Navy will constitute him also as Commander-in-Chief of the country. That's something. I have no illusion that any decision by this court can keep power in the hands of Congress if it is not wise and timely in meeting its problems. I mean, really, this is constitutional law today, right? We may say that power to legislate for emergencies belongs in the hands of Congress, but only Congress itself can prevent power from slipping through its fingers. With all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government, except that the executive be under law and that the law be made by parliamentary deliberation. Such institutions may be destined to pass away, but it's the duty of this court to be the last, not the first, to give them up. Stirring or what? The Morissette case. I love this case. I love this case in criminal law. I love this case in criminal law. This is the case of the fella who goes on to what was still apparently Air Force property, but there were bomb casings there, old bomb casing, and he figured that they were abandoned. The government didn't own them anymore. But anyway, so he gets prosecuted for stealing the bomb casings under a law that prohibited conversion of government property. They said, I didn't know there was government property. And there was no proof in the case that he knew it was government property. But he's convicted anyway. And Jackson writes the opinion of the court, which has been cited a whole bunch of times in the last 10, 20 years, that whether or not a statute actually says that there's a mens rea, a scienter, somebody must have known about this particular fact. Whether or not the statute says that, that doesn't mean that the prosecution doesn't have to prove that the individual did know. And then he says the contention that an injury can amount to a crime only when inflicted by intention is no provincial or transient notion. It's as universal and persistent in mature systems of law as belief in freedom of the human will and a consequent ability and duty of normal individual to choose between good and evil. Crime as a compound concept, generally constituted only from the concurrence of an evil-meaning mind with an evil-doing hand. It was congenial to an intense individualism and took deep and early root in American soil. As the state codified the common law of crimes, even if their enactments were silent on the subject, the courts assumed that the omission did not signify disapproval of the principle, but merely recognized that intent was so inherent in the idea of a criminal offense that it required no statutory affirmation. Then he says, in this case, the government asks us by a feat of construction radically to change the weights and balances of justice. The purpose and obvious effect of doing away with the requirement of guilty intent is to ease the prosecution's path to conviction, to strip the defendant of such benefit as he derived at common law from innocence of evil purpose. Such a manifest impairment of the immunities of the individual should not be extended on judicial initiative. Mere omission of any mention of intent will not be construed as eliminating that element from the crimes denounced. Actually, fairly recently, Clarence Thomas just wrote an opinion citing this like crazy. Chief Justice Roberts wrote an opinion citing this like crazy. The Court of Appeals recently wrote a decision. No, they never mentioned this, and they ruled the other way. They made a crime a strict liability crime. So we still have this issue arising all the time. Finally, let me deal with this. The Albany Law Commencement. Listen to these words. Listen to them. The next few years may look grim and drab to the men of my generation, but you must have the eyes to see the world that lies beyond these difficult times. I say this to my students all the time. A world in which nothing, absolutely nothing, will be impossible of achievement. You must look 20 and 30 years ahead. You must see on the horizon a world in which there will flourish science and art of civilized men to live peaceably and comfortably together in a society of law and dignity. May you never falter in the faith that a better world order can be established and that the philosophy of the law can lead the way to it. That was his commencement here at Albany Law School. Pretty darn great, huh? Okay, well, thank you very, very much, Philip. Thank you.
We're coming close on time. It's this one. Yeah.
Good evening. It's going to be very hard to go after these distinguished speakers, but today my remarks is going to be more like about the focus of the contribution of Justice Jackson around the world. Thank you, Dean. Thank you, Associate Deans, colleagues, students, everyone who made it in today to be able to see really what Albany Law has produced. And I am a strong believer that we did it before, we can do it again and again and again. That's very important because when it comes to Justice Jackson, around the world, it's the real deal. To have someone like him who's willing to take time off to make a difference, it's phenomenal. Now, Justice Jackson made this extraordinary decision to actually take time off and step away from his comfort zone and went abroad for an entire year. So what really brought to Nuremberg was not simply prosecution, but really a commitment to legal process, to fairness, like John said earlier, and to the idea that even after war, justice must remain grounded in law. So I say this because, like we saw the first two presenters, the World War II has already occurred. Hitler died, and they were already planning to do the right thing. And Justice Jackson was, send me. And he responded, like John said, once his president asked him, would you do this? He said yes. And I think it's very important to see that he didn't just go to Europe to have fun or to just accepted what the French were saying, essentially in their legal system with the civil law, is almost like guilty until proven innocent. But Justice Jackson was like, I am American, I'm going to respect the rule of law, and I'm going even to accept the possibility of finding some innocent man because the evidence, it has to be real. So that's, when we think about his impact in Nuremberg, it's really, really important. So we move power to law. So basically, the stress shifts from state versus individual responsibility. Nuremberg really marked a turning point because the first time you're going to have now the opportunity to prosecute individuals. So the idea that before we used to see under international law in some cases, some would say, oh, they forced me to do it. That's why I did it. So you want to tell me you kill all these people? So your idea of duress is no longer going to take hold because now we are looking at really accountability for individuals, not just states. Because as you know, under international law, you need to have the state consent. And Justice Jackson is like a new sheriff in town. This time we are looking for individuals. What you have, the wrong that you have committed, we are going to make sure that we prove it, we show the evidence, and for you to be accountable. So I think that's very important. And importantly, the process included safeguards that we have in the US: legal representation, evidentiary standards, acquittals. So this was not simply punishment, it was adjudication. So Nuremberg makes us think today the idea of justice versus legitimacy. Justice Jackson was not going to be engaged in some form of trial and just say, let's just put them in jail. Let's just make them pay for what they've done. He wanted to prove it. And even in watching the movie that shared with me for the first time. I get to watch it. So you really get to see his action before the court and really make sure that everything is proven for the evidence standpoint. So you have the idea of victor's justice, concern about retroactive criminalization. So Nuremberg was not without criticism, should I say. Many criticize Nuremberg because they describe it as a victor's justice, questioning whether the law was being applied equally, because it wasn't just the Nazis, there were other allies that, according to some research, maybe who didn't get to be prosecuted. So there was this idea, well, was it really fair? Yet I submit to you what really makes Nuremberg different is that Nuremberg Indoor is that it attempted to place legal constraints on power, even in the moment where it was so hard to define it. And as I'm taking you around, we're actually going to go a little bit, should I say, around the world, so that you will really see the commitment and what Justice Jackson was able to accomplish. So we look and we see, we could say there is something that we call some form of unfinished project. Because after Nuremberg, we would say, okay, then what? I believe, I submit, with all humility, we have John here, and I think that Justice Jackson, from the very onset, intended to create some form of international tribunal to really render justice. But after Nuremberg, we saw almost about 45 years, my math is really bad, from 1945 to 1990. So despite its significance, Nuremberg did not immediately lead to this permanent system. For nearly 50 years, I'll say, the vision of international criminal justice remained unrealized and shaped by geopolitical division, institutional hesitation, because by then we know we have the UN Convention, but we have our famous Chapter 7. The Security Council, we have the Big Five that can veto almost anything. And also we see that this gap was also due to, we moved from after the Second World War to Cold War. The idea, the problem between Russia and the United States. So in the 1990s, international community then returned back to Justice Jackson's framework. And it was the idea that now we can create new tribunals. For instance, we go to the Yugoslavia. We see that coming, and I will submit to you that without the Nuremberg Tribunal, we would not have seen Yugoslavia Tribunal. I don't believe we would have seen the Rwanda Tribunal. So basically what Justice Jackson has done for the world by providing this kind of style of looking at how to really prosecute those individuals. And when the time comes, except this time, it was happening at the same time. The Yugoslavia Tribunal, the atrocity was ongoing. The Rwanda Tribunal, the atrocity was ongoing. Meanwhile, with Justice Jackson, what he did, it was afterwards. So I would submit to you, for instance, if you see here, there were other, like I call them hybrid tribunal that came afterwards. Those hybrid tribunals, they are very important because they didn't have the consensus under the UN Convention or consensus for all the countries. We are talking about 194 countries. And lately I heard there are 2 more coming on the market to want to be countries, states. And we know that under the Montevideo Convention, you cannot just be a state unless you prove certain things. So with the ad hoc hybrid tribunals, it did something very phenomenal. First of all, we look at Sierra Leone from 2002 to 2013. So prosecuted leaders responsible for civil war. For the first time, we were able to prosecute a former head of state. Some would say, Rose, that's why the ICC is designed for African leaders. So I would say, no, I beg to differ, because it's not just African leaders that's been prosecuted. Perhaps a lot of them, but it's not, ICC is not just designed for just African states, because you have a group of states. I think last time I checked, about 125 countries are members of the Rome Statute, so including those 33 countries in Africa. So we see that there is also Cambodia, 2006 and 2022. I say all of that we can thank Justice Jackson for, because with those hybrid tribunal, we have a blended international and domestic judicial system where the state itself would call on to the international community to create those hybrid systems. Then we have the Special Tribunal of Lebanon from 2009 to 2003, which addressed political assassination and terrorism, applied international criminal law within a national framework. Before Justice Jackson, it was not, we wouldn't be able to get that far. So these tribunals reflect a move towards hybrid justice, combining international legal standards with domestic institutions. That's very important, because if the domestic courts, if they don't agree to go forward, you cannot find a consensus, then you have no way to move forward to render justice. So each of these hybrid tribunals is designed for a specific context, illustrating both innovation and fragmentation in the development of international criminal law. So even when you have these hybrid tribunal, depending on the state consent, sometimes you have to have some other form of mechanisms. So let's go beyond the courts. Sometimes when you cannot create the famous Nuremberg Tribunal like Justice Jackson was able to, you see, you can have the hybrid. But in other instances, you cannot have the hybrids, but this time you are looking beyond the court. But yet you still want to have some form of accountability mechanisms when justice cannot be delivered. What do? We look at Syria. The IIMM, which is the International Impartial Independent Mechanisms, that was created in 2016, designed to collect, preserve evidence of war crime and crimes against humanity. That's very important. That is consistent with Article 6 of the Nuremberg Charter, crime against humanity. And then you see that by creating that Syria IIMM, they prepare case files for future prosecution. So the answer is, if we cannot do right now what Justice Jackson was able to do in 1 year, let us preserve the evidence that's still in his memory, in his liking. Let us maintain that so that in the future, whenever, however remote this would be, because there is no statute of limitation, however remote this would be, then maybe we can bring that claim against that individual. So we also see ISIS, Iraq, United Nations Investigative Team, UNITAD, from 2017 to 2024. These are documents of mass atrocities committed by ISIS, including genocide. Also, we can see that was a support for national and international criminal proceedings. And also Myanmar, which is the IIMM, Independent Investigative Mechanisms for Myanmar. We won't be able to go through all of them. So the point is that without Nuremberg, we wouldn't be able to have the idea, this framework to create, whether it's a tribunal or just some form of way to maintain the evidence and be able to prosecute. So for Myanmar, it was investigating crimes against the Rohingya population, and it builds the evidence for future accountability. So then we come, you would say, well, Rose, well, maybe I should have shown you this first, but I show you this because the ICC is very distinct. How is distinct? Because the ICC, you go by the Rome Statute. This is just to show you that Justice Jackson, in my view, probably intended to have this form of a court from the very beginning, but it took us about 50 years because we keep on fighting with each other. We couldn't get it together. So finally, in 1998, this is when we have the Rome Statute. And for those of you who do international law, you know that the United States is not a party to the Rome Statute. The Rome Statute, that's what created the ICC. So basically, international court would begin in 2002 when we finally have the Rome Statute taking effect. So with that, I would say, because of Justice Jackson, we can say that we were always part of it. We were always part of it. But it's just so happened we did not maintain it. Now I submit to you that maybe there is still hope because I'm a law professor. I have students and Van and John, and that's the idea. Because right now my former professor would probably be very proud to see me presenting about it, to tell you that United States, we were always at the very beginning. And the idea is how do we maintain to stay and continue having such involvement? So the ICC present the institutional realization of what Nuremberg made possible, but could not complete. That's my submission to you. And you would see that, for instance, how the ICC works. The jurisdiction is over a core international crime. Complementary national courts take the priority. It relies on state cooperation. So when you have this treaty, which is the Rome Statute, and United States, who was at the beginning say, hey, I'm not going to accept the Rome Statute, and by the way, have objected to many other jurisdictions. So you have many other states now who are following the United States who have not been member of the Rome Statute, countries such as Haiti. So you want to ask yourself why. It's not for any reason that we are a leader in the matter. I believe when we take greater stand, other countries are likely to follow, but not yet. And we don't have time to go into why the United States has not accepted the Rome Statute. I discuss it a lot in my class, but you can just have an idea. Really, we don't want you to prosecute our people abroad. We have a great legal system. Justice Jackson proved it in Nuremberg, and we've done it very well here in the United States, and we are going to maintain that, as opposed to give you an opportunity to take our possibly prisoner of war or people who're defending us abroad for you to prosecute them. So whenever I'm doing this, I always think that it's very important to quickly tell you there is a difference between ICC and ICJ, because a lot of people can conflict them sometimes. So ICC, really, the distinction is essential because, like I said earlier, ICC is really concerned about the individual. So now your excuse that, oh, well, I acted under duress. We saw some of these cases in our books. Well, I killed, all these Muslims or Jews or whatever because I was forced to do it. ICC stopped that because you are going to be held accountable for your own action. So essentially, international law operates through multiple forms of accountability. Each has its own limitation. International criminal courts would prosecute individual, whereas the ICJ is concerned with really state to states. So it's a little bit, and even though some of the cases we would have before the ICC could arguably be heard by the ICJ, but to really maintain the docket for the past 10 or 15 years, we see that the ICJ mainly is concerned with issues states to states, border issues, resources, but not just going into criminality of specific individuals as to human rights violations. So I think it's very important that you understand that it's the idea of criminal responsibility for the individual versus the state responsibility, which may not be criminal, but yet some form of failure of a state responsibility. So, United States now. So where are you? Well, the United States played, I would say, a fundamental role in shaping international criminal law. Like you see, Justice Jackson did that by really did an excellent job in Nuremberg, and that's why we're here today to honor him. But yet, as I have submitted to you earlier, United States, for some reason, remain outside of the ICC framework. The US has not ratified the Rome Statute, which went into force in 2002. So even though we have a system to criminalize individual, the US is still outside of it. So where are we today? Well, where are we today? Today, international criminal law is no longer retrospective, I would say. We have the Ukraine, which is active ICC engagement. We see that there is, I believe, the prosecutor Khan in the United Kingdom. I think that's his nationality. That's the prosecutor. He has a warrant for Vladimir's arrest. That's an active engagement. Gaza, Palestine, where we have contested jurisdiction. And the law continues to operate under political pressure. And I always say to my students, I'm sorry, I don't have answers for you. I guess we will see what happens. That's in terms of, because you always, even if we were to go tomorrow before the UN General Assembly and we say, we want to have a tribunal, it's not going to work like that, because we know that it has to go before the UN Security Council, and we have the Big Five, and somebody may decide to veto it, and we go back. So I think for the past years, what we've been doing is this kind of collection of evidence and I'm sure, even though we have not yet created something to collect evidence, some people are already doing so to make sure, in the interest of keeping alive Justice Jackson's impact, that we can really prove it in the future, however remote that would be. So my final reflections is that the law is a response to atrocity, institution built but unevenly. Justice remained contingent on the political will of these states. So I believe Justice Jackson showed the world that law could confront atrocity. The question that remains for us today is whether we have the collective will to ensure that law continues to do so instantly and without exception. I think that if Justice Jackson was still alive, he would really stress on, do we have the will to continue doing this together and without exception? That means, and we saw what he did with Nuremberg, is really not taking any side, be impartial, and be the excellent prosecutor that he was, and really bring it home for the world to see what justice is like. Thank you.
Take one or two questions. Does that sound good? Yeah.
We'll take a couple questions from the stands, even from the panelists.
I have.
Judge Carey.
Oh, So on the international sphere, I understand we're not part of the ICC, but are we part of the ICJ? We take part in that, right?
Well, I turn back to the 1986 case, which is the Nicaragua case. Yeah, Judge, what happened back in Nicaragua, the U.S. served as a third party to go to the aid of some Sandinistas, and finally, it was determined, the case went all the way to the ICJ. It was determined that our action was the wrong action. I guess last time we had this meeting, we said it was similar to R2P because responsibility to protect when the third party asks the state to intervene. So in that sense, since the 1986 case, the United States determined, well, I don't like this reasoning that you're gonna ask me to pay some reparation, forget it. And then they make a decision to say, ICJ, no longer shall United States accept your jurisdiction. So, Judge, as we speak today, ICJ does not have jurisdiction now. However, there is still a way to bring a case against the United States, as you know, under ICJ statute, Article 38, which is like you can do first through the treaties, second, customary international law. So if when United States says no jurisdiction, if there is an issue, you can prove there is a violation of customary international law, then yes, you can still bring it before the ICJ.
And even when the United States in the recent past has said, well, we will succumb to the jurisdiction of the ICJ and participate, the ICJ rules against the United States. Who's going to enforce that? Right? I mean, who's going to enforce that? There was the case involving the Vienna Treaty because we had failed, well, the state of Virginia had failed to advise the Mexican consulate and allowed the defendant to speak with the Mexican consulate before they tried him and imposed the death penalty. And the ICJ said, you can't do that under the Vienna Convention. You have to allow the Mexican defendant to get in touch with the Mexican consulate. And so that's the decision. And what happened, the United States Supreme Court said, well, yeah, that's your ruling, but, and then the court came up with one of these things, well, for some reason, the Vienna Convention with regard to allowing foreign defendants to get in touch with their consulates, they said, well, Congress has got to legislate to put that into effect. And someone might say, wait a minute, what do you mean Congress has got to enact legislation to put that into effect? That's a treaty. We're bound by it. And then the question now is in international law, and I don't know how you answer it, but I never have an answer. How do we know when there's a particular treaty where the Supreme Court is going to say it's not self-effectuating? Congress has got to pass legislation in order to effectuate it. And what treaties are those where, well, once we enter into the treaty, we're bound by it? Who knows? I don't know.
I don't have an answer to that. I just have a little PS. The United States is a bad defendant in the ICJ, as most states are. And obeying an adverse judgment is really what Rose points out, the Nicaragua breakdown and so forth. The U.S. is a party to the ICJ. The U.S. is represented by Judge Sarah Cleveland, former Columbia Law professor, is a U.S. judge of the ICJ. So, there are different American positions, if you will. But unlike the ICC, we are, as a state, in that process.
Can I? Yeah. And also, Judge, United States, even though it has not accepted the court's jurisdiction, like you said, Judge Cleveland, before that, it was Judge Donahue. Yeah? And she was actually the president of the court. So what I think the United States has always done, which is for those treaties that Vin just mentioned, there is always some reservation because under the Vienna Convention of the Law of Treaty, they can enter a reservation so long as you prove that reservation does not violate Article 18 of the Vienna Convention, basically saying, well, my reservation is not in conflict with the purpose of the treaty. So obviously, if you are a party to the Genocide Convention, you're not going to have a reservation that I can't commit genocide, for instance. So I think that's how the United States has always done it. And some of those treaties are so important that even when the other parties may not want the reservation, but they want the United States on board, we need the United States to sign it. So, okay, we'll accept the reservation. So the treaties are not self-executing, even though Article 103 of the UN Convention says the domestic law is inferior to the international law. The US said, wait a minute, our constitution, we need to go before the Senate for the 2/3 vote. We can't do that because this, even if I sign this, it's not going to be okay anyway. So that's how they are sitting before the Senate, because the Senate has not, accept those treaties. So.
Clearly more complicated than I had even thought of. Thank you.
I have just a little Jackson nugget connecting to the ICJ. When Nuremberg finished, it was a one and only international trial. They didn't re-up the London Agreement and do a second international trial. So the judgment, October 1, 1946, was the end of the international Nuremberg process. And Robert Jackson went home to the Supreme Court, and that court disbanded, but it had all the stuff that, of course, a court has, such as the records. And Nuremberg had been recorded on wire reels. I don't quite understand the technology, but the audio was preserved on these wire reels. And luckily, somebody sort of figured we need to find a permanent institution. And the World Court, the ICJ, had been created coming out of Versailles after World War I. So they shipped all that stuff to The Hague. And it sat in the basement in wooden crates for about 50 years for that whole Cold War period. And luckily, ICJ librarians love librarians, like in the pantheon of human heroes, librarians. ICJ librarians preserve this stuff in nooks and crannies. And eventually, in this century, people decided it was worth some money, it was technologically feasible, it all got digitized. And so today, out of the basement, out of the crates at the ICJ from Nuremberg, we have the internet audio that allows us to listen to Robert Jackson, at great length, day by day by day at Nuremberg. So it was a great parking space for Nuremberg records.